I move to adopt the determination that no open meeting violation occurred at the board's May 15th, 2023 executive session, and therefore no cure is necessary.
Welcome to the 208. I'm Joe Paris. That is the University of Idaho situation, talking about moving forward with their plan to buy the University of Phoenix. And the Idaho State Board of Education is doubling down that this is the right decision for Idaho, and they made no mistakes along the way, according to them. However, Idaho Attorney General Raúl Labrador thinks otherwise. His office says that the State Board of Ed violated open meeting laws, and the AG's office, well, they're filing a lawsuit in response. And this is a perfect time to bring in Andrew Bartline. And Andrew, you did the hard work here today. You read through the lawsuit. You kind of gleaned it down, followed the board meetings. What do people need to know about this?
Well, it boils down to two specific dates, Joe, and we'll get into those right now. It's May 15th and May 18th. So on the 15th specifically, the State Board of Education held an executive session to discuss a business matter. Now, that meeting was closed to the public. 3 days later, on the 18th, the State Board of Education voted to approve the University of Idaho's agreement to purchase the University of Phoenix. The AG's office says that first meeting was closed without proper cause, therefore making it illegal, which in turn makes the vote to approve the University of Phoenix sale invalid. And if the State Board would agree to that, the AG's office said they would not serve their lawsuit. Well, the State Board of Education held a special meeting this morning to consider the AG's allegations. The State Board took 30 minutes and they came to their own conclusion.
The attorneys engaged in this transaction determined that the exemption applied. Even now, with the benefit of hindsight analysis, we believe the exemption applies, therefore no violation occurred.
You hear the word in there, exemption. Idaho does require public agencies to keep meetings open to the public, but exemptions do exist. That May 15th meeting minutes, they show that it was a closed executive session, but they also directly cite their exemption too, pulled straight from Idaho code. Quote, to consider preliminary negotiations involving matters of trade or commerce in which the governing body is in competition with governing bodies in other states or nations. Then the board voted 3 days later to approve that acquisition. Well, the AG's office put 2 and 2 together, and the lawsuit says this exemption did not apply. The lawsuit offers multiple reasons behind their complaint. First off, the AG points out the language preliminary negotiation. The lawsuit says this meeting is not preliminary at all. Rather, it was considering the final terms of sale, which comes out to more than $500 million. If the State Board of Education concluded 3 days later to greenlight that sale, the lawsuit says the negotiation is better described as advanced than preliminary. Now, there's a second level to this too, but it's technically the same complaint in this lawsuit, again against that same exemption. The exemption cited also requires some level of competition. The exact language of the lawsuit, or the law, I should say, says in which the governing body is in competition with other governing bodies, other states, nations. So at some point we know there was competition. The University of Arkansas considered buying the University of Phoenix, but their Board of Regents rejected a $500 million proposal themselves back in April. So that means the University of Arkansas was no longer in competition with the University of Idaho by that May meeting. The AG's lawsuit says they have no reason to believe any other university was actively creating competition in that sale either. The State Board of Ed says they are now moving forward with their sale nonetheless, and the nonprofit arm that would absorb the University of Phoenix, it still needs accreditation, so it's not a done deal yet. But the AG's lawsuit, Joe, would look to block this. If they were successful with this in proving that that open meeting law was violated, well, it would render this void and it would block all action.
So I guess where do we go from here? Do we know if this is like a wait till the lawsuit's resolved situation?
That's what it would have to be at this point. And the State Board of Education put out a statement today saying that they are preparing to get private attorneys, private lawyers, because the Attorney General is, of course, on the other side. They're not going to be backing them up in this lawsuit.
So a little sticky legal situation that I know we'll be watching, because we see your comments. People very interested to see how this University of Idaho potential combination with the University of Phoenix will go. So Andrew, we'll keep an eye on that. Thank you so much.